So without further ado, I'll pass you on to Sarah Wilson of Knights.
Thanks, Gemma. Afternoon, everyone. Hope you're all well. So today's topic is smash and grab adjudication. Now, we had quite a lot of debate probably about 18 months ago, just prior to the pandemic, about whether it was still valid, if you could still do it, how, when to use it, etc. So this is sort of a follow-up on that. Is it still worthwhile doing it? Spoiler alert there, yes it is. Otherwise, why would we be talking about it? But it's probably in slightly more discrete circumstances where you need to be thinking about it. So topics we're going to cover today. So we're going to look at payment notices, the whole procedure, and the implication of developers' failure to issue a payment notice or payment certificate, or effectively the employer, if you're on an NEC form of contract, client, of course, if you're on NEC 4. Please don't forget, contractors in our virtual room, that it also applies to you issuing your payment notice when you're engaging a subcontractor under a subcontract. So we're going to look at what smash and grab is and when it's effective. So steps for the contractor. So when I'm talking about contractors in this scenario, it's the party being paid. So it also applies to the subcontractors in the room. So steps for you guys to take to try and protect yourselves, and steps for project managers, clients, employers to take to make sure they don't get caught out by this. So normally in these seminars, when we're talking about NEC, what we're looking at is clauses that you contractors and subcontractors need to be aware of to protect yourselves, because there are some really nasty clauses in there, particularly where you miss a deadline, and if you do miss that deadline, you find that you're not entitled to payment or time. So we know that's the case with notifying compensation events, for example. This is the other way around. This is where you, as contractor, subcontractor, can be prepared and possibly get yourself into a position where you're entitled to bring a smash and grab adjudication, which is, for once, good news for you guys. So if we move on, so what we're looking at here, typical kinds of construction disputes. Let's put the smash and grab in perspective. So you'd have a contractor's interim or final account, ditto subcontractor. You might have a defects claim. So typically a defects claim would be after completion. Usually what you find is that they proceed to court, so fairly traditional. Procurement disputes, ditto, go to court. Where we see adjudication is on the contractor's account, final account, and stroke or interim. And that's where we need to be thinking about this so-called smash and grab adjudication. So where does it all come from? Because this isn't just the ordinary common law. This is absolutely unique to our industry. No other industry has the benefit of these provisions. So it all comes from what we know as the Construction Act, the Housing Grants Construction Regeneration Act, 1996. So just a bit of history. It was amended in 2011. So in that first phase, 1996 to 2011, we had no opportunity to do this smash and grab adjudication, because effectively party wanting paid would submit an interim payment application, and there was no right to any payment unless the employer submitted a payment certificate. And once that payment certificate was submitted, subject to a subsequent withholding notice, if you remember the old withholding notices, equivalent of a pay less notice, subject to one of those being issued, then the payment certificate was like issuing a cheque. You were guaranteeing that money would be paid. If no payment certificate and no withholding notice was issued, then the contractor's only remedy was to adjudicate on the merits of the claim. And when we talk about adjudicating on the merits, it's sort of the opposite of a smash and grab. You're looking at, well, what's my claim? Or, well, it's, non-payment, a disagreement about a variation or a compensation event. So you guys, as the claimants, the party wanting to be paid, has to prove every element of that claim, that it's extra work or one of the compensation events, to prove the quantum attached to it, etc. So it's quite onerous for the party wanting to be paid. The government of the time obviously didn't think that was working too successfully, so they sort of reversed the situation in 2011 when we had this snappily entitled LDEDCA, Local Democracy, Economic Development and Construction Act. So we're interested with the last bit of it. So it was effective from October 2011. So it's been in place for 10 years now. And what it means effectively is that the contractor has the power to drive interim payment process. And if the developer, so the paying party, fails to issue either a valid payment notice or a valid pay less notice, they can issue both if they want. But if they fail to issue either, and the contractor's issued an interim payment application, or what we call a default payment notice, then you have a smash and grab scenario. So as I've said already, this is a key risk area for developers, for clients, for employers. They need to know and understand this. But you guys do as well for your subcontracts, not only for your subcontracts, but also so you can get yourselves in a position where you can be saying, look, we have a smash and grab situation here, we're entitled to be paid. So effectively, the new regime since 2011 has been that whatever sum has been in the prevailing document must be paid by the final date for payment. So what would the prevailing document be? Well, if you look at the second main bullet point here, we've got the hierarchy of those prevailing documents. So first of all, the developers, this is the paying parties, pay less notice. That's the top of the tree. That document, providing it's submitted properly, trumps all others. Then if that's not submitted, the next one down in the hierarchy is the developers, the paying parties payment notice. So then, and this is where the smash and grab opportunity arises, the next one down is the contractor's interim payment application, IPA. If that's not been submitted, and none of the other two have, then the next one, the one at the bottom of the pile but prevails if the others haven't been submitted, is a contractor's default payment notice. So that's how it's worked. So effectively, it's the same scenario as we had pre-2011, that when we say one of these documents prevails, it effectively prevails as the equivalent to a cheque. So the pay less notice, the top one, says that a certain sum is going to be paid to the contractor or subcontractor in a subcontract, then that is the sum that must be paid on the final date for payment. If the developer hasn't submitted any notices, hasn't submitted pay less notice or payment notice, contractor has submitted an IPA though, then in that scenario, the IPA prevails, and that is the sum that must be paid on the final date for payment. And where the idea of the smash and grab comes in is quite understandably, if that scenario prevails, the contractor's IPA is the one that is to be paid at the final date for payment. Generally speaking, the paying party isn't going to be very happy, because usually there will be some reductions. In particular, if you think about it, towards the end of the project, there may be, a substantial number of items that are not agreed. So there could be variations, extension of time, loss and expense sums in there. And if they're in that IPA, and that prevails, then contractor or subcontractor and a subcontractor is going to be saying, this is the amount payable. And you can see there why the paying party is not going to be happy, because it's going to be substantially more than the sum that they think is due, but they have got to pay. That's the rule. And it is harsh, but as I've already said, it works both ways, because particularly in the NEC contract, there are harsh provisions for contractors and subcontractors to comply with. So if at that point contractor's IPA isn't paid, so by the final date for payment, then contractor or subcontractor is in a smash and grab situation and can commence an adjudication simply on the basis that its IPA is the prevailing document and therefore ought to be paid. No requirement to prove what the claim is. No requirement to go into any detail about, well, this was a variation, the cost of it was X, it's a variation for these reasons. None of that is relevant at all. All that is relevant is contractor submitted an IPA in the correct form, paying party hasn't submitted a payment notice or pay less notice, and therefore this is smash and grab scenario, payment must be made. So hopefully you can see, particularly if you've been to adjudication on the merits, how useful that can be. If you haven't ever been to an adjudication on the merits, what I can tell you for absolute certain is that, it's not that rough and ready process that it was intended to be. You have to provide a lot of evidence, go into a lot of detail. So that's why this is a really, really good mechanism and a good way, as I say, particularly towards the end of a project where, the delta between what is being paid and what the contractor or subcontractor is applying for is increasing and increasing, because if you can get that money paid, then you're in a position where you can potentially have some good negotiations with the paying party to agree an account, rather than having to go through a great long adjudication where you're looking at the merits. So it's not, as you might have gathered, not quite as simple just as submitting an interim payment application. And this applies to both parties, and it's always the same when there are onerous consequences for either submitting or not submitting a document, a notice, which is what we're talking about here. For both parties, the interim payment application, default payment notice for the party being paid, and also the payment notice and the pay less notice for the developer, they must fulfill certain criteria or they'll be ineffective. So that's where this sort of kind of slightly tricky bit comes in. So what's the criteria? Well, first of all, all of these notices must state the amount the particular party submitting it considers is due at that point, and the basis of calculation. So bear that in mind. Now, when you think about an interim payment application, you probably comply with that automatically, because there'll be a breakdown as to the main contract sum. Hopefully, there'll be a breakdown of variations, loss and expense, extension of time, or if you're on NEC, your compensation events. So usually that's pretty much tailor-made just by the way interim payment applications are prepared. Note, if you're going to do a default payment notice, and we'll see where that applies in a few minutes, try to stick to the same format. Similarly, the paying party, when they submit a payment notice, usually what they do is go into the interim payment application and, either tick or cross, state the reasons why they're not paying certain things. So, usually that will fulfill that criteria. Project managers, employers, clients, please be careful when you're submitting your pay less notice, because that must fulfill the criteria or it'll be ineffective. So, the amount due, basis of calculation. So typically there, you'll be saying the amount due because you'll be making a deduction typically from your payment notice. Basis of calculation, it's typically, not always, going to be some defects have been found subsequent to the payment notice, in which case state that and how you've calculated the deduction. Of course, bear in mind, paying party, if you haven't submitted a payment notice and you've gone straight to pay less notice, you're probably going to have to go through the contractor's IPA and mark up exactly what you're paying, what you're not, and where you're not paying, the reasons, etc. So that's your first criteria. It must state the amount due and basis of calculation. Also, second criteria, it must be given at the correct time. That applies to all of these notices, and we're going to look at the timescales. What I would say is we're going to look at the timescales in the standard forms of contract, but what it is a good idea to do at the start of the works is to establish, once you've started, what the timescales are with the other party, so that you don't get into a muddle later on in the project. Couple of points to note: an interim payment application, it must be clear it's an IPA. What we saw, so that's the Caledonian and Mars City is a case that went through the courts. Very briefly, what happened here was, I suspect what's happened is the party wanting to be paid had submitted something that wasn't in the normal format of an interim application, because it was a sort of probably a draft type of final account, something like that. It wasn't submitted in time, and it wasn't a timescale one. This was about, the format that it was in, and the paying party didn't recognise it as being an interpayment application. I suspect you're probably okay if it. What typically, where the lawyers somebody starts to look back in the file and find something and tries to say, we'll say this is an interim payment application, and we have a smash and grab scenario. So just be careful if you do change the format of your, it's probably going to still be that it is an IPA, but just make sure. Also a late IPA, so we know that you've got to submit it on time, but what if you submit it late? Can it suddenly convert into the next, usually the next month's or the next instalment of IPA? And the court in Henia Investments and Beck Interiors said absolutely not. Again, for obvious reasons, this is, these are about notifications. And if you think about that, a notice, it's all about the other side receiving it and, understanding the purpose of it. It's not about, tricking a party into. So if you have a smash and grab scenario, what's your remedy? Well, as I've already said, your first remedy is to say, well, the final date for payment's gone past, so please, Miss this is paying party, can you make payment? Payment's due. If they refuse, then you've got a smash and grab situation. Potentially, you can always suspend, which is another right that we have under the Housing Grants Act. Please remember, you've got to give 7 days notice before you suspend your work. And that's a legitimate thing to do. What I would say before you do suspend, you should, I would suggest you should take legal advice, because you weren't entitled to, so don't have a proper smash and grab scenario, then you'll find that you have suspended the contract, works in breach of contract, so you then have to bear the costs of suspension. So that almost inevitably will mean that you're paying liquidated damages for that period, and also bearing your own costs. So, it sounds a really good, easy, cost-effective remedy, but just be careful before using it. You might want to threaten it, but as soon as works are suspended, everybody's losing out costs-wise, and someone will have to bear that cost, and it'll be the suspending party if they have suspended in breach. So there is a ground it is often a ground to terminate the contract, so bear that in mind. Typically, you're not going to want to do that, but of course, in some instances, you might want to. Again, before you start terminating, I would strongly advise you to get legal advice about whether it is a valid ground for terminating, because again, if you get it wrong and you terminate and you're not entitled to, that will be costly, because you will have terminated in breach, and you will then pay the cost consequences of it. The other option is to start winding up proceedings, quite aggressive, and what you might find, we haven't had any instances of that recently, it's not really the way people go. You might find that a court wouldn't like that, because they would say you've got all these other remedies, including smash and grab adjudication. One point, we had the case of Galliford Tryner Stura, where I think it was about £6 million was awarded by way of smash and grab adjudication. It was all disputed, and the court refused to enforce that adjudication in full. I think they awarded about £3 million to be paid immediately, so that was bad enough for the paying party when it was all disputed. But again, when you're thinking about smash and grab, if it's going to be a huge amount, sometimes you've just got to be a bit cautious, because it's unlikely that the court's really going to want huge sums like that being paid over, because this is all on a temporary basis. So this is how the mechanism works. So very, very basically, we've got a flow chart here. So the first stage is, this is the perfect scenario. This is the mechanism working properly. So at the top, you've got contractor submits its interim application for payment. We'll deal with timescales and the detail later. This is just broad brush. You then have the due date. Timescales be looked at later, and then the date for the paying party to submit its payment notice. If that's submitted, that's the notified sum. So that's the sum that's paid at the final date for payment, subject to any lower figure in the pay less notice. So the pay less notice comes next, if it's going to be submitted. It's not always. And then you have the final date for payment, which is when payment is made. So that's broad brush how the mechanism should work. As it says there, and we've already seen the 2 bullet points, the notices must all be submitted in the correct timescales and in the correct form. So the correct form, remember, stating the amount due and the basis of calculation. So this is where it goes slightly wrong for the paying party. So the contractor submits its interim payment application. The next step down, due date, as before. In this instance, no payment notice is submitted within the timescales by the paying party. So at that point, if you look to the right of the slide where we've got the notified sum, is the sum in the contractor's interim payment application, subject to any pay less notice submitted by the paying party. So if you go back to the flow chart, you then have the time for the paying party to submit the pay less notice. If that isn't submitted, then you've got the final date per payment, and the notified sum is the sum in the contractor's interim payment application. So that's classic smash and grab territory, because of course the paying party doesn't want to pay the amount in the interim payment application. Final date for payment comes and goes, nothing's paid, and at that point contractor is entitled to start smash and grab adjudication, or any of the other remedies we looked at. So potentially suspend, potentially terminate, and if wanting to be very aggressive, start winding up proceedings. And the next slide covers off the default payment notice that we've sort of talked about, but not in a huge amount of detail. So when does that apply? Well, in certain circumstances, now, why would that be? Well, it might be that it's not submitted, it was submitted, but or it might be or there is a rule that says the interim payment application only applies, it only has any force as the sum to be paid in a smash and grab scenario where the contract states that the party to be paid is either entitled to or must, so may or must, either way, submit an interim payment application. If the contract is silent on the paying party submitting an interim payment application, then it always has to rely on this mechanism that we're looking at now with the default payment notice. Otherwise, it can rely on the default payment mechanism notice if it forgets to submit the payment notice, or it's not in the right form, etc. So you would still have a due date, and there would be a mechanism, this is compulsory, for the paying party to submit a payment notice. So sometimes it is left that the paying party, submits the payment notice without having had any information, so any interim payment application from the party wanting to be paid. But if the paying party forgets to submit the payment notice, the time has gone by to do that, then contractor can jump in at that point and submit a default payment notice, and at that point that becomes the notified sum, so the sum to be paid at the final date for payment, subject to any pay less notice being issued by the paying party. So as you can see underneath that, we've got the pay less notice and then the final date for payment. So that's how that mechanism works with the default payment notice. Right, so that's the point I've already talked about. So I'm going to look at the timescales for both JCT and also NEC. Now, JCT vary in timescales depending on which contract you use. So we're going to look at the design and build contract. So please do be aware, all the timescales are different under JCT, as are the clause references. There will be in similar places, but not the exact place. So, you'll be able to use this, but it's just guidance if you're on other forms of JCT. So the first thing that we have in the design and build is the contractor's application for payment, so interim payment application. There's a similar one for subcontractors, but obviously that will be in the JCT subcontract. What we have is a due date for payment. So that is the later of the date for the contractor's application, so interim payment applications. It's the later of the date in the contract for it and the date the interim application is received. So effectively, nothing happens on JCT, design and build, until an application for payment has been received. So that's quite nice for the contract administrator for JCT, because they know that they don't have to do anything until they receive that application. If they don't receive an application, the mechanism doesn't start. So it's quite nice from that perspective. Where it's not great is that the contract administrator has very little control over it. So, for example, not a great scenario where the application for payments received when the contract administrator's on holiday, doesn't check their emails, doesn't have someone checking things, and the clock immediately starts running with regard to this mechanism. So that's the due date. Then not later than 5 days from the due date, we have the date for the payment notice to be submitted. So you can see, where that can be problematic in this scenario where contract administrators on holiday, possibly off sick, and nobody's properly covering their work. So if they don't submit that payment notice, then they've got the opportunity, we know, to submit a pay less notice. So how do you work that day out? Well, we've got the due date. The difference between the due date and the final date for payment is 14 days. The pay less notice has to be submitted. It says here not less than 5 days. That's clause 4.9.4 in the square brackets there. Not less than, it's a double negative, so it effectively means 5 days or more than before the final date for payments. If the due date is the 14th of the month, final date payments the 28th. So if this is February, 28th of February, pay less notice has to be submitted at least 5 days before that. So 28th, that's going to be what, the 23rd. So, 22nd of February is okay, 23rd is, 24th, that's too late. So just be careful, contract administrators and also contractors and subcontracts, about the wording with that pay less notice. The logic here is that you would never have a notice where you are telling another party that you're going to actually pay them less than they think they're going to get, where it says not less than 5 days, but effectively you can tell them the day before the final date for payment. That just doesn't make sense, does it? It's got to be 5 days or more before the final date for payment. Quite often we see all these timescales amended, and what is really common is to say that instead of not less than 5 days, it says not less than 1 day, so it effectively becomes the day before. But that's not great for parties when they're expecting payment. So that's the JCT timescale. NEC looks and to an extent is slightly more complicated. The first thing you need to work out, so this is slightly different in terms of when does the paying party submit the application for payment. It's effectively, as it says in that right hand box, on or before the assessment date. So that's clause 51.1. Bear in mind here that the payment provisions are in 2 places. They're at clause 50, 51, etc., but also at Y2, which is where you'll find the Housing Grants Act provisions. So application for payment from the party wanting to be paid is submitted on or before the assessment date. So that's clause 51.1. So what's the assessment date? Well, You can find out, and these are the 2 bullet points at the left-hand side of the slide, the assessment intervals are set out in the contract data part 1. So that's the contract data submitted by the paying party. So typically it'll be monthly, or it might be every 28 days. Monthly's much simpler, but it depends on the party. So that's the assessment interval. So you're going to get interim payments every 28 days or monthly or whatever it states. So what about the first date to get the ball rolling? Well, the first assessment date is decided by so this is the second bullet point on the left. It's decided by the project manager at the start of the project and must be within that first assessment period. So if your assessment period is monthly, you start on site the 2nd of February. Before the 2nd of March, the project manager must tell the contractor what the assessment date is, and it must be within that period. So it couldn't be the 3rd of March, the 4th of March. It's got to be within that first month period. If the project manager doesn't do that, and contractors, ditto subcontractors, if you're not being told, my advice would be contact, the project manager or the contract administrator if you're in a subcontract, and ask them what the date is so that, everybody's clear about it. If the project manager doesn't notify a date, then it's the end of that first assessment interval. So if your monthly assessment intervals, you start on the 2nd, then it's the 1st of the following month. So it's when you've done a full assessment period. So that's how you work it out. It's a bit tortuous, which is why, I think it's always sensible to discuss it, because of course we are on the NEC, it's supposed to be a collaborative contract. So we know what the assessment date is, and this is slightly different to JCT in that it doesn't really matter under NEC if the contractor submits an interim payment application or not. It's just got to submit it on or before the assessment date for it to be valid. Now, contractors, subcontractors, why wouldn't you submit one? And if you don't submit it on or before your application date, so if it's out of time, if it's after that date, then it's not going to count for a smash and grab adjudication as a payment notice at all. So please, work out this assessment date and make sure you get your payment application in on or before it. But then we have the assessment date, and we know that that's set in stone. That's a fixed date. And on the left-hand side, we can see the Housing Grants Act days. 7 days from the assessment date, we have the due date. Due date doesn't really do much, except it's the trigger for the final date for payment. So lots of people think, the due date is the date for payment. It's not. It's the final date for payment. So it's funny terminology to someone who's not familiar with all of this language. So within 7 days of the assessment date, we have the due date. On the right-hand side, we can see that a week, so also 7 days, from the assessment date, we have the date for the certification or the payment notice by the project manager on a contract. So that's the date that the payment notice has to be submitted. We also know that 14 days from the due date is the final date for payment, and so that's the bottom of this flow chart. And if you look up from that, it says that the date for the pay less notice is not later than 7 days from the final date for payment. So again, not later than. It's basically saying it's 7 days or greater from the final date for payment. So as before, if your final date for payment is the 28th of the month, your final date for submitting your pay less notice is going to be the 21st of the month. 20th is okay. 19th is okay. 22nd is too late. 23rd is too late, etc. So that's the time scale under NEC. So when smash and grab is effective, so what we've basically seen that it's when you don't submit a notice in time. Oh, actually, sorry, I forgot. So we've got the default payment mechanism on this slide here. So you can see that as soon as that certification or payment notice hasn't been submitted, if the contractor hasn't submitted an application for payment, or hasn't submitted it within time, or it's not in the right form stating the amount due and the basis of calculation, then at that point, contractor can come in and submit a default payment notice. And of course, the paying party still has the right to respond and dispute that by putting in a pay less notice. So what happens when you are successful in your smash and grab adjudication, or alternatively where the paying party accepts that it hasn't submitted its notices properly and makes payment without having to proceed to a smash and grab adjudication? Well, in that instance, they are entitled to have the merits of the matter heard and effectively claw back the sums that they shouldn't have had to have paid based on the merits. So on that basis, for example, if you're in month 1 of a project and all you've done is contract work and no payment notice is submitted, but paying party doesn't think that that was the right amount payable. For example, paying party may think that, for instance, the interim payment application says that 20% of the work's been completed. Paying party says, no, it was only 10%. You are unlikely to start a smash and grab adjudication, and the paying party is unlikely to pay you, simply because by the time you've run the adjudication, you're probably up to the next payment notice when 20% of the work will have been completed and you'll be entitled to be paid. So effectively, the payment process would overtake the adjudication smash and grab. So, it's probably not worth doing it at that stage. But as I've previously said, if you're getting to the stage where the project's nearly finished, or there's a big delta between what the paying party has paid so far and what the contractor or subcontractor has applied for, then in that instance, it probably is going to be worth it, particularly if that delta, as is usually the case, consists of disputed variations, compensation events, extensions of time, and the cost of that time, etc. When the volume of the work is reduced, then it's worth doing, because also, if you think about it, if you're successful, month 3 on a smash and grab, and you're only 20% of the way through the project, what the contract administrator will do the next month is simply deduct the payments from you. And generally what will happen is that the developer, the paying party, once they've paid out on the adjudication, on the smash and grab adjudication, will be entitled to counter adjudicate on the merits. If you remember, going through looking at, well, the smash and grab included all these variations, clearly they're not proper variations, contractor's not entitled to them, so we're entitled to that money back. So that would be the next step to be taken by the party who's paid, and we'll see a little bit of this when we look at the case law in a couple of minutes. So how can the developer, the paying party, protect itself? Well, it needs to ensure a number of things. These are all organisational. They're all very, very tedious, but if you get them right at the start, you can't go wrong. So need to be clear that the assessment dates, the assessment valuation dates are clear. Make sure they've been timetabled and diarised. So that's both payment notice and pay less notice. If I were a project manager, I'd also be diarising assessment dates, so I know that they're coming up. It's always an idea with these things. As project manager, it's rare that you are a person operating within your organisations completely on your own. So put them in someone else's diary so that there's a checking mechanism, and the dates aren't missed, because it can be so onerous for the dates to be missed. The first smash and grab adjudication I had, it was probably very shortly after the new rules were brought in 2011, and it was a consultant who was the project manager. They'd come in late in the project, and they'd partly been engaged because they had said to the developer, you are missing all these dates for payment notices, and that can be absolutely fatal to you. Use us and we'll make sure we don't miss the dates. Famous last words. They sort of didn't miss the dates because they knew when the payment notice had to be submitted. They were ready. They submitted it by email, but it was really unfortunate because when they I can't remember the name of the person at the contractor's end who was who the notice had to be served on, but when you do your drop down box and you're looking for John at another organisation, by accident they clicked on John within their own organisation, sent it to John who worked within the consultant's organisation. Unfortunately, John was on holiday and there wasn't any bounce back on his emails. So it wasn't until he got back from his holiday that they all realised that it had been sent to the wrong John. And it hadn't been served. So contractor in that case applied for and obtained smash and grab adjudication for several hundreds of thousands of pounds. And there was nothing that could be done except, and that was right at the end of the project, or towards the end of the project. So, they were going to have to re-adjudicate or start court proceedings to claw the money back that they thought they'd overpaid. So be really, really careful about this. I would say the contract administrator should notify the developer, the paying party, depending on that party, but I would notify them as well, just so that they know that they might be consulted about it. Also, I think it's always good to ensure that you've got pro formas for both your payment notice and your pay less notice. So if you're in a rush to do them, etc., you're not going to forget the criteria, which is to include the amount due and basis of calculation. Also, critically, and we'll see a case on this, you need to check that the method of serving your notices are valid under the contract. Now, these tips also apply to contractors and subcontractors for getting yourself into a position where you can you can be in that nice scenario where you're in a smash and grab adjudication, which will benefit you because the project manager hasn't administered this mechanism properly. So check the method of service of notices in your contract. Generally, under NEC, email is fine, which is how these all tend to be done. Generally, though, under JCT, it's proper service, of service by post. So, try to get an amendment into your JCT so that you can serve these notices by email, because it's just so much easier. Quite often, these documents become quite cumbersome, and they're pretty hopeless to look at in hard copy anyway. So, email is the sensible way to serve, but just be careful about that. Right, so just got a couple of cases to look at, and then we'll close. The main two cases on smash and grab is this first bullet point, ISG and CVIC. You'll see that's a 2014 case. So that was, as you will see, shortly after the 2011 legislation was introduced. This is where the courts, and don't get me wrong, we had effectively been having smash and grab adjudications between 2011 and 14, but this was the chance where the party who was having to make the payment on the basis of the smash and grab subsequent to an adjudication said, no, we're not paying. We want the court to see if this smash and grab malarkey has any basis at law. And as we had all, well, as the lawyers had expected, the court said yes, it is valid, and if you don't get your notices right and on time, then paying party must pay, even though there may be no real merit in the claims. Now, what they said was that it was on the basis that if the paying party hadn't submitted either of its notices, payment or pay less, then it was deemed to have accepted the sums that the party wanting to be paid had submitted in its interim payment application or default payment notice. So that was quite important. It was deemed to have agreed and accepted that that was the sum due. So it didn't need, the paying party didn't need to submit a notice. Now, that was a sort of slightly false basis, because of course it wasn't. It was just because they'd forgotten to serve their notices usually. So following this CVIC case, generally we were all a bit uncertain as to what the paying party had to do to get its money back. Could it re-adjudicate? Because of course we have a rule that you can't re-adjudicate a dispute. You can go to court, you take it to court, you can't adjudicate. So would that be re-adjudicating if you adjudicated it on the merits? Or would it be distinguishable? Would you say, well, the first was a special type of adjudication, it didn't consider the merits, this is different? Or did you have to take it to court? And also, did you have to wait until the final account stage before you could deal with it? So sometimes, waiting to final account, that was problematic with NEC because we don't have it. But with JCT, of course, that's right at the end of the defects period. So we had one where it was JCT, where I did a smash and grab adjudication. We were awarded just over £1 million on it, and the paying party had to pay that money, and it was well over a year until it got to the final account process before they were able to start thinking about recovering that. So, that is a long time to be held out of that money. Now, fair enough, a small amount was paid back, not the full amount, because the parties effectively agreed that something was due to my client on that matter. But the other thing was that the party trying to claw back the money, it was really easy to see that they were struggling, because they're not used to having to show the merits of a claim for getting money back when they didn't really know the basis of the quantification of the payment in the first place. So, it was really tricky for them. So we then had in 2018, so 4 years post CVIC, the case of Grove Developments and S&T. And unusually, the judge in this case effectively overturned Grove, because they said, look, this isn't a deemed or an implied acceptance, it's just an error. They recognised that the paying party omitted to submit a payment notice or a pay less notice. And what they said was, yes, smash and grab adjudication still applies. If the paying party doesn't submit the notices or submit them correctly, then they do have to make payment, but the paying party can then immediately re-adjudicate on the merits, but the burden of proof is on them, the paying party, to prove exactly how much it is entitled to. So on mine that I was just talking about, where they'd had to pay over £1 million, they would have had to have shown why every single penny of that £1 million had to be repaid back to them, which, would be an uphill struggle. And is therefore a huge deterrent, and is often why what happens is party successful in a smash and grab, the money's paid over, and then they get into some sensible negotiations to talk about what realistically should be paid back, so that neither party are having to re-adjudicate. The caveat here is, and this is the final case, which is Davenport and Greer, so 2019 case. What the courts have very clearly said is the paying party cannot re-adjudicate, so they can't adjudicate on the merits until they have paid the sums due from the first smash and grab adjudication. So it's still painful for that paying party. Just a few other cases. This first one is for the parties wanting to be paid, so contractors in a contract, subcontractors in a subcontract. If, as is often the case, you have a schedule of payments attached to your contract to set out how the payment mechanism works. It's a really good way of doing it because it's just really clear to everyone. You can put all those dates in your diary and there can be no dispute. Please be careful what happened in this, Grove Developments and Balfour Beatty. Balfour Beatty was the contractor here, so the party wanting to be paid. The schedule of payments went from the start of the works up to the completion date. Great, that's fine. But what happens if completion isn't achieved by the completion date? It's often the case. And as contractors, subcontractors, you still want to continue submitting your interim payment applications because you haven't been paid your full contract sum. And of course, there may be further variations or changes or compensation events after that completion date. What the court said here was they took a very literal approach and said, no, the payment mechanism is as per the schedule of payments. Those payments only go up to the contract completion date, and therefore, even though the contract completion date is extended, there weren't any payment dates after that. So it meant that Balfours had to keep working through until they got to the final account, and only at the final account stage could they make a recovery for that work subsequent to the contract completion date. So please do have your schedule of payments, but you need something at the end that makes it clear, if the project goes beyond these dates, then the dates will be, will follow, make it very, very clear, every month thereafter. Or it's even quite dangerous to say, well, we'll add an extra 6 months on, because that's assuming that you won't be delayed by more than 6 months. Because if you are delayed by more than 6 months, you've got the same problem. So, excuse me, just be really careful about that. Next case, Kersfield and Bray and Slaughter. So this is 2017. For obvious reasons, these are all, really up to date. So notices must be served on time. So if you're out of time with any of your notices, you are really, really going to suffer. And particularly if you are the party wanting to be paid, if your notice is out of time, that's a really easy way for the adjudicator to say, no, this isn't smash and grab. I'm not awarding you this money, because, this is quite an onerous mechanism for the paying party. And this is the point, in accordance with the contract. So this is about, serving it properly. There've been cases where, for example, a notice has to be served within working hours. So, if somebody serves it on the correct day, but they've had a busy day, so they serve it at 7 p.m., that notice is invalid. It doesn't count for anything because it's not served in time. So you've got to be really careful with these things. And also, finally, the form of the interim payment application is important, particularly so because, of course, if you're in a smash and grab, you contractors, subcontractors are going to be relying on this to say, this is what I should be paid. So this is the point, that the courts want it to be something, want it to be a notice that the project manager, whoever is going to be submitting a payment notice in response, or a pay less notice, can easily recognise it as an interim payment notice. Don't think, well, I'll try and disguise it. So they don't think it's an interim payment application. It might go under the radar and they might not submit a notice, because the chances are you'll try a smash and grab adjudication. The adjudicator will see through that and say, no, it's not in the correct form. And in this case, what had happened was that Logan's interim payment application, it was in a completely different form to previously, and the parties were also talking about draft final accounts. So it was a bit of a muddle as to, was it a draft final account or interim payment application? And quite simply, the adjudicator decided that if there's any doubt, no smash and grab adjudication would be awarded, for obvious reasons, because, as I say, it is so onerous. So that's it. Oh no, sorry. Thought that was it. So just a couple of points about under certification. Oh, sorry. This is just, yeah. So this is moving away from smash and grab into merits basis. What can you do if you haven't got a smash and grab scenario? So you've got this delta increasing and increasing every interim mechanism, where paying, the party who is wanting to be paid is continually applying for more and more, and continually being, in its mind, under certified, but there's no smash and grab scenario. Well, in that case, what you can do is still adjudicate on the merits. So that's a good way to proceed. It's also good to catch that quite early, because what you can do is adjudicate a discrete item. You don't have to adjudicate the whole account. So, for example, if you had a large variation, a large value compensation event that was fairly straightforward, you could just adjudicate that. Excuse me, get an award on that, and then at least you've got some money in there from a cash flow, and then look at the other disputed items. Don't need to do them all at once. And yeah, and under certification can relate to, so it can be the extent of the work completed. One says 50%, one says 70%. It's not usually any use adjudicating that, because by the time you've got to adjudication, you've caught up with the certification anyway. Typically, it's variation claims to changes in work, claims for extensions of time, so where liquidated damages or delay damages are being levied, and you want to claw that back, and or you want your costs relating to that extension of time. So again, and this is not related to smash and grab, but this is where contractor. Subcontractor has notice requirements, so make sure that you're complying with your notification requirements. They exist in both JCT and, as we know from compensation events in NEC, you've got to notify promptly, or they might be time barred. So just be careful about that. So that's just a couple of little points on merits adjudication. So that's everything done today. I hope that was helpful.